This is a law that was going to require everybody that owned a corporate entity, an LLC, a partnership, to disclose the beneficial owners. What's up, everybody? Jared Seidenberg, Pine Financial Group, coming to you with a little update on some legal legislation and some case law that has just recently been passed. I committed to you guys that we're going to keep doing a series like this, and I want to bring you as much content as I can. But before we get there, if you found us on YouTube or you found us on Facebook or wherever you found us, give us a like, subscribe to our channel, drop a comment below. As you know, we are trying to build community here, and we want to make sure we're bringing the content that you guys need to help you be successful in your real estate endeavors and in life, really. That is our plan. And so if you got anything you want to say here, drop us that comment. We will make sure that we respond. If you want other content that you're not getting, let us know. We'll do that too. Today, what we're going to talk about is the Corporate Transparency Act. This has been a big deal this year, everyone. This is a law that was going to require everybody that owned a corporate entity, an LLC, a partnership, to disclose the beneficial owners. Now, it doesn't sound like that big a deal. And I did a video earlier in the year when this was still coming down the pipe about complying with it. And I questioned whether this was a big deal or not. It feels invasive to me, but there's a public policy about wanting to get to the owners of companies. Now, I will tell you, as an attorney, this one really kind of bothered me because part of the reason of forming corporate entities and LLCs is to give you that asset protection, to be able to use that alter ego. We've got a concept about piercing the corporate veil, which gives you shield from potential personal liability when you use the company properly. And this seemed to invade on that, and it seemed to be a little bit overbroad. And what has happened just this week is that now a federal district court in the state of Texas has decided that this is unconstitutional. Now, what the court said was that the legislators overstepped their ability to regulate and to occupy a sphere that is normally held for the states. Now, what that really means is it comes down to this argument of federalism. Do you believe in big government? Do you want the federal entities to come in and tell you what you can do? Or do you want everything at the state level? I'm not going to opine about what's right and wrong there. Everybody's got their different opinion. And sometimes I have a different opinion on what I think the federal government should do and what the states should do. But what this court said was that regulating entities in this way and requiring information is something that the states should control, not the federal government. And so what they did is they issued a preliminary injunction on the enforcement of the CTA. What that means for all of you listening and watching out there is that you no longer have to comply with this law. It has been put on pause. Now, the temporary injunction, the preliminary injunction, is somewhat loose in that it could be overturned. We don't know exactly what the appellate court might do if it does get appealed, and there will be a final rule on this, and there may be a permanent injunction on it. But for right now, that law is no longer enforceable. The federal government does not have the right to go in and ask for this information. And so what that means for the 32 million companies out there that this was going to apply to is that you no longer have to do what the law said. You don't have to give the information. The government doesn't have to collect it. You're not required to report into the federal agency that was set up to handle all this stuff. The court in Texas estimated that this was going to cost small business owners and large business owners too, for sure, over $22 billion in compliance to make sure that this was happening. They didn't believe that that was fair either. So there was really a two-prong attack. They didn't think that the federal government should be in this area and should not be regulating companies like this. And they were concerned with the cost on businesses, which 22 billion bucks, guys, that's a lot of money, right? So right now, state of the law, the CTA has been enjoined. It is a preliminary injunction. It is no longer enforceable. It means for you that if you've already complied, fine, your information's there, but you don't have to keep the ongoing compliance that was required. If you have not complied, and the deadline to comply was at the end of December 2024, you don't have to. And so you can stop those efforts, and we will see what happens. Obviously, we've got an administration change coming in 2025. There is some indication that that administration will attack the CTA in some form or another. The court may wait for that to happen. The federal government, through the new administration, may moot this decision and just repeal the CTA. They may try to carve around the edges and make it compliant, but this is a really big deal, especially for our smaller real estate clients and people that are landlords and have small businesses and these things. Complying on the beneficial owner requirement was going to be difficult. I know you're thinking, well, how hard is it to just tell people who owns the business? But as you all know, none of it is just that easy. It's not just as simple as an email. So this will change the way that you have to file your business organizations, and it'll lessen the compliance apparatus that you have in disclosing those beneficial owners. And those people that joined as limited partners or otherwise in certain types of corporate structures that didn't want their information to be out there in the public, even the general partners that didn't want to be out there in the public, now will get their wish and everything can go back to the way that it was. So this is the new stuff. This is hot off the presses. So I wanted to bring it to you quickly. I know we get a ton of questions about the CTA and how to comply with it. And of course, as a lender, we've been concerned about the compliance as well, because we have some obligation to make sure that the companies that we're lending to are being operated correctly. So this takes another layer off of us as well in our underwriting and our due diligence. So as we said, the CTA has been preliminarily enjoined. My guess is that this stays into effect. And for those of you that were loathing the idea of providing this information or grumbling about it or just didn't quite understand why you had to do it, now you don't have to worry about it. Court is taking care of that for you. It's a federal court in Texas. We'll see with the next shoe to drop, but for now, it's on pause, guys. So enjoy the anonymity that you may have behind your corporate veil. Do things right. Don't ever do something that's going to expose you, because regardless of the CTA or anything else, if you're not operating the company right, you don't get the protections of it. This is just one less regulation that everybody has to comply with. And I know there's people out there that'll welcome that change. Please let us know what you think. I'm totally interested in hearing people's comments on this. I'll try to reply to all of them. Drop them below. We'll get back to you. Again, Jared Seidenberg, Pine Financial Group, coming to you with a little legal update. And I hope everybody has a great holiday season out there, and we'll look forward to doing business with you next year. Thanks.